In this section, we will explore telemarketing rules. The Telephone Consumer Protection Act holds significant importance for mortgage loan originators as it establishes guidelines and restrictions for telemarketing and the use of automated telephone equipment. The TCPA aims to protect consumers from unwanted and intrusive communications such as unsolicited telemarketing calls or text messages. For MLOs, compliance with the TCPA is crucial to ensure they adhere to the legal framework surrounding communication practices with borrowers. By requiring prior consent from consumers before making automated calls or sending text messages, the TCPA helps protect individuals' privacy and prevents them from being bombarded with unwanted communications. MLOs must obtain express consent from borrowers before using automated dialing systems or pre-recorded messages to contact them. Failure to comply with the TCPA can result in significant penalties and potential lawsuits. Overall, the TCPA plays a vital role in safeguarding consumer privacy rights, ensuring that MLOs engage in responsible and respectful communication practices while conducting their origination operations. Now let's dive into the Act's creation and some of its most important key points. In an effort to address the growing number of telephone marketing calls, Congress acted in 1991 the Telephone Consumer Protection Act. The TCPA restricts the making of telemarketing calls and the use of automatic telephone dialing systems in artificial or pre-recorded voice messages. The rules apply to common carriers as well as to other marketers. In 1992, the Commission adopted rules to implement the TCPA, including the requirement that entities making telephone solicitations institute procedures for maintaining company-specific do-not-call lists. On July 3, 2003, the FCC revised its TCPA rules to establish, in coordination with the Federal Trade Commission, a national do-not-call registry. The National Registry is nationwide in scope, covers all telemarketers except for certain nonprofit organizations, and applies to both interstate and intrastate calls. On October 1, 2003, the National Do Not Call Registry went into effect, and telemarketers were prohibited from contacting numbers on the list unless the calls were exempted under the rules. The registry was adopted in large part to make it easier and more efficient for consumers to prevent unwanted telemarketing calls. Consumers can add their landline and wireless telephone numbers to the registry either online or by calling a toll-free number. When the registry was first established, telephone numbers were to remain in the registry for 5 years. A consumer could re-register a number at the end of the 5-year registration period. On February 19, 2008, Congress enacted the Do Not Call Improvement Act of 2007, making registrations permanent and prohibiting the automatic removal of registered telephone numbers. In addition, the FTC must periodically check numbers in the registry and remove numbers that have been disconnected and reassigned. Let's take a minute to explore actions that are prohibited under the Telephone Consumer Protection Act. Specifically, the TCPA provides that it is against the law for any person within the U.S. to make any call other than a call made for emergency purposes or made with the prior express consent of the called party, using any automated telephone dialing system or an artificial or pre-recorded voice to any emergency telephone line, including 911 and any emergency line of a hospital, medical physician or service office, healthcare facility, poison control center, or fire protection or law enforcement agency, to the telephone line of any guest room or patient room of a hospital, healthcare facility, elderly home, or similar establishment, or to any telephone number assigned to a paging service, cellular telephone service, specialized mobile radio service, or other radio common carrier service, or any service for which the called party is charged for the call. Furthermore, it is against the law for any person within the U.S. to initiate any telephone call to any residential telephone line using an artificial or pre-recorded voice to deliver a message without the prior express consent of the called party, unless the call is initiated for emergency purposes or is exempted by rule or order by the Commission. Additionally, it is against the law for any person within the U.S. to use any telephone, fax machine, computer, or other device to send an unsolicited advertisement to a fax machine. Finally, under the TCPA, no person in the U.S. may use an automatic telephone dialing system in any such way that 2 or more telephone lines of a multi-line business are engaged simultaneously. Under the TCPA, those sending fax messages or transmitting artificial or pre-recorded voice messages are subject to certain identification requirements. The statute also provides consumers with several options to enforce the restrictions on unsolicited telemarketing, including a private right of action. The telemarketing sales rule and the FCC's TCPA rules provide a few additional provisions to protect consumers from harassment and abusive telemarketing practices. First, telemarketing calls may be only placed between 8 a.m. and 9 p.m. in the time zone of the consumer being called. Furthermore, abandoned calls are prohibited. A call is considered abandoned if a person answers it and the telemarketer does not connect the call to a sales representative within 2 seconds of the person's completed greeting. Additionally, telemarketers are required to transmit caller ID information when available. Furthermore, threatening, harassing, or intimidating persons is prohibited. And finally, telemarketers and sellers are required to keep specific records for 24 months. These records include, but are not limited to, promotional materials as well as telemarketing scripts.